Hello. Are we on? Are we
Yeah,
live?
we are.
We are live. Well,
Yeah.
hello. I don't know whether anybody is there, whether anybody can hear me. My name's Nicholas Bowen. I am the alleged head of the education team at Doughty Street Chambers. And we're going to give what I hope will be a stimulating, shortish talk about education negligence. I confess, because of my great age, this is the first time I've ever done a webinar, so it could be a disaster. It could be a triumph. I have absolutely no idea. So anyway, I believe now is the time for me to say slide one. Slide number one, please. Look at that. Absolute magic. So, disaster or triumph? Now, first of all, I can't see anybody. All I know is that one of my old co-conspirators who invented this area, Mr. Rabinowitz, said he would attend, but because of the tech, I have no idea if he is there or not. But this entire, I was going to say failed type of litigation, but we'll talk about that, comes from, as I'm sure everybody who's online knows, two famous cases, Exon Bedfordshire and Phelps, and has spawned an enormous amount of judicial and academic interest. Great hope. Hope springs eternal, save in this area. And law indeed entered the classroom in about 2000 in this very controversial case, building on Exon Bedfordshire. Now, I won't ask you to flick to them yet, but you will see in due course on slide 4 and 5. Can we just put those up quickly, please, so we can see them? So I don't want to get lost in the detail. I attempt to do a sort of nutshell guide to Exon Bedfordshire in slide 4 and slide 5. And then in slide 6 and slide 7, we deal with Phelps. Now, I'm only supposed to be taking 15 minutes, so I probably won't have time to go into that. But that is all there. Oh, you're going ahead. So 4, 5, 6, and 7 is the classical celebrated House of Lords decisions about which invented the area. Now, controversial from the beginning. Back to slide 3 now, please. Controversial from the beginning. In about 9 years on, after what we will see was the development of the area, the liberalization of tort law, access to justice for people who had been absolutely let down by the system. But by 2009, the famous, some would say infamous, Lenny Hoffman wrote quite a well-known article, and I tried to, it's been taken down as far as I can see, or at least it doesn't seem to exist online anymore. But he described Mr. Rabinowitz and mine and Mr. Tahar's and various other Mr. Friel's perambulations in the House of Lords in 2000 as a, quote, unqualified disaster for this country's education system. And he called it reforming the law of reforming the law of public authority negligence. He did, as far as I recall, go off and do some of his own research because there was very little data in this area, and came up with a figure. I don't know can't remember what the figure is. If Jack is online, he will be able to tell us and remind us. But it ran in, I think, if not into the tens of millions, the hundreds of millions. So our success in establishing this duty of care, the detail of which I will talk about presently, has cost the taxpayer a significant sum of money, according to Lord Hoffman. Of course, those who are proponents of the jurisdiction will say it was a fantastic development of the common law, and what's happened subsequently via the Court of Appeal and judges at first instance, for understandable maybe policy reasons, closing it down through causation, well, breach, causation, limitation, and damage, i.e. the cases aren't worth very much. It's all been a bit of a false dawn. Now, there have, of course, been rays of sunshine on the way, but they have been fairly limited. Now, when we decided to give this webinar, I was asked to have a quick look at that's right, an authority, a case law update. Well, there's not very much to update, sadly. There's an awful lot of history, and I don't know whether you are all interested in the history. But if, please, we skip to, where do we skip to? We skip to 12. Have a skip to 12, right? No, keep going, keep going, keep going. This is very clever. Right, now here, now this is a sign of my own, this list, which is purely historic, and I anticipate probably nobody, maybe apart from me, will be interested in, is a sign of my own undiagnosed neurodiversity and difficulties. I became, if not autistic, and ADHD led me to spend far too much time on Westlaw, seeing how long Phelps had been referred to, how much recent activity there had been. And if we just look quickly at the list, one of my clever colleagues, Sarah Steinhardt, had what an incredibly long judgment, the top case, Cody and Vogel and Remus. That might be worth a look in terms of a potential claim that somebody might have in relation to a dysfunctional private school. They won on deceit, and also they won on negligence. Funnily, it didn't come up initially because they didn't refer to Phelps, but they did refer to Siddiqui. Siddiqui is one of my own clients, God bless him. I didn't do the case because my advice to Mr. Siddiqui was, do not spend your money suing the University of Oxford. I think I can say that properly and publicly, because if you read the decision, I think from memory, the reference there is a reference to Mr. Justice Kerr's decision at the trial, but I think there's also a Ousley J decision on strikeout, as far as I recall, subject to correction. It was a loss. It was a broken life case, as so many of these are, and it was a disaster. Major costs orders, but a very interesting case, a very interesting judgment. And we'll go back actually to that in a minute. If, as I'm on Siddiqui, could we flick please to the types of challenges, which is slide 9. And there we have Siddiqui, got the reference there. As I haven't reread it for the purposes of today, but Siddiqui from memory was a man who took a fairly historic, I think when he was in his 30s, challenge to the manner in which one of the one part of his prelims, or one small part of the of his degree, was delivered by a teacher, a don, who was seemingly, I think with some justification, not up to scratch. And his argument was that he would have got a 2, instead of getting a 2-1, which he got, he would have got a first because he was on the borderline. So it was a near miss case. And I think there was a fair bit possibly potentially in the challenge, but it literally took over his life. And he proceeded, and one of its history now, the case was lost on a whole for many different reasons. But it's now notable for a very useful summation of the type of challenge. You see paragraph 41. 41, tort or, I'll read it to you. Claims for negligence educational provision take various forms. They're notoriously difficult to win, but that has but that has been held not to be a good reason for excluding the existence of a duty of care. In private law claims founded on tort or contract, as distinct from public law claims, normally brought by judicial review, principles well settled. He then says, I can't attempt a full exposition because it's also complicated, but there are three broad categories of claim. The first category is academic judgment. So that's where a claim asserts a breach of duty owed in tort or contract. So it can either be against the state or an independent institution, arising in the exercise of the defendant's professional teaching staff of academic judgment. An example would be a decision to award a particular grade to a student sitting in an exam. Such a claim is not justiciable as a matter of law and is therefore liable to be struck out. Clark and University of Lincolnshire. There is in fact another decision, I'm afraid I didn't find it in time, but Mr. Justice Males, I think from memory, who says it's not actually quite that simple. And so don't take that as an absolute, a completely accurate summation. There are circumstances where that can be an entry point. Second category is, of course, the big one, which spawned all the activity in the 6 or 7 years, or 5 or 6 years after the Phelps decision. Second category, negligent teaching methods. In devising the courses or the means of acquainting students with the educational content of the courses being taught, such claims can be actionable in principle, Phelps. However, because the claimant's attack is on the competence of the defendant's performance in the exercise of skill and care in a profession, the merits of the claim must be assessed by reference to Bowen. And as we'll see when we look at some of the other slides, Bowen, the need for expert evidence, the need to show a suitable standard of care has again been a reason why so many, in fact, the bulk of cases that have come to court have failed. What I don't know, which of course the solicitor's profession will be in a much better position to know about, is the number of cases that successfully settled. And I dare say, and I don't suppose Lord Hoffman, when he did his informal research, was able to work out exactly the extent to which rights had been wronged and people had been compensated. Maybe in some of the more extreme cases at a level which is higher than the typical level that we would see in these cases, which was typically on a blamere basis, as I recall, about 25,000 for the loss of a chance of earning at a higher rate, along with a relatively limited sum for psychological injury, distress and anxiety. Now, the third category, simple operational negligence. So teaching the wrong syllabus, drunk teacher, cancelled classes. What Mr. Justice Kerr said was, in that type of case, unlikely that you would need expert evidence, or it was conceded that you wouldn't need expert evidence. Supervision arrangements in the context of higher education as well. That is an area which certainly I've had a fair few cases. None of them have actually come to court. Some of them have settled. Some of them have just sort of died in the ditch. Could we just go back to 3? Because I started with a, may or may have been with a flourish, but didn't actually go through the go through some of this. So we got to Lord Hoffman. I've covered in a little detail what happened, and we'll go back to slide 9 in a moment. But for those of you, if there are any junior members of the profession who weren't around 20 years ago, in fact, somebody will have to tell me when, but legal aid eligibility under I was at the Courts and Services the Legal Services Act took away legal aid for both PI cases and either at the same time or subsequently for this type of negligence claim, unless you could get a HRA claim going or some form of serious abuse by a public authority, most obviously deceit or misfeasance. So there were ways in. once the public funding went, that led the rump of people with deep pockets who could take on either the state or private education institutions. Solicitors stopped taking the cases. Staff were redeployed. And certainly, I mean, I used to be very, very active in this field, not so much now because I got a broader practice taking on other limbs of the public service in terms of failure to protect cases against the police and the criminal justice system. But certainly, subject to correction, there were only 2 education providers with legal aid contracts. What the position is now, I'm not so sure. Now, where to go now? Scope of duty. Let's have a quick look at slide number 8. See what we have there. So we covered this a little bit looking at Siddiqui, but in terms of the original position under X and Bedfordshire, what had happened in X, I won't go over the facts, it's in the slides that I assume you'll have and keep. But X, a combined, conjoined social services and negligence case. Social services aspects failed because of policy. All of the policies are set out in one of the slides, I think either the first or the second slide. The fourth or the fifth slide, you'll see all those policies. Multidisciplinary, too expensive, tending to stimulate defensive decision making, etc. So the claims against the local authorities for either failing to remove something that is now so current with HXA and YXA, or intervening and removing in error when they think a child's been abused but actually hasn't. Those cases all failed in limine, but the education cases succeeded. They didn't succeed on the basis that, on one of the primary bases on which they were formulated, which was all to do with the failure to assess, something which, of course, now for keen students of this area, if anybody's followed HXA and YXA, you will see the very disappointing, incredibly conservative position taken by 5 Supreme Court justices that all of the child protection failures and failures to assess under Section 47 on the way to a care order are not or cannot really in reality, although they left a tiny little chink, amount to an assumption of responsibility. Well, maybe long forgotten to an extent, but that's exactly what Lord Brown Wilkinson was saying in X and Bedfordshire. And he said the policy closed that down. That is consistent with the law as it now currently stands in the child protection world. But what he did decide on the basis of a mistake is that the Education Psychology Service was a public service and was open to the public, and accordingly it was just like a hospital. So that's how it all started. And then in Phelps, it was broadened out effectively to bad teaching and a failure to diagnose learning difficulties of one form or another. Now, just a point quickly, I'll have to close up relatively quickly, I think, otherwise I will filibuster my colleagues. I think that's my first warning that people may or may not be able to see. Neurodiversity, ADHD, dyslexia born again. I wonder, somebody suggested to me that maybe there might be scope for some form of class action in relation to that. Individual cases will be as difficult as they ever were, and funding problems will continue. Could we now just have a quick look at, because I'm running out of time, number 13, the new approach. The new approach, right. Now, there have been, I'm sure probably, I'm sorry if I'm telling people how to suck eggs here, but I have no idea of the depth of knowledge of either the one person listening or the 43 people listening. It's the most bizarre thing. I mean, I've never done this before and query whether I'll ever do it again. if anybody's listening, you may or may not know about some famous cases. I'm sure you do. If you don't, you should be heavily chastised because I was in them. Michael, that's a 999 case. That's the one that started the move towards what happened in Poole via Robinson. The state is not there to bail you out of all potential problems just because there's a statutory welfare system. It explained the immunity of the police as being based on the omissions principle rather than the rather than policy. Robinson started the move, the distinction between causing harm cases and failure to confer benefit. And then that happened in Poole. Tyndall is one that we're arguing, and it's listed. We've got a listing in the Supreme Court in June, which is all about what constitutes making matters worse. Now, I'm going to stop in a moment because I will talk everybody out. But this is what follows is really quite complicated stuff. Read in the summary there about what Robinson established. And the question is, what, if anything, does it mean for this jurisdiction? Well, it's not going to touch duty issues as per Phelps, bar some kind of earthquake and going back to the Supreme Court, because they are now explained as an assumption of responsibility and standard private law cases, standard private law principles. But it has struck me that it may be possible to reorientate certain cases, and we're very interested always in Doughty Street in looking at what other people think are hopeless. When I was brought in to lead in Robinson, and actually even my colleagues thought it was a no-hoper. So what looks like a no-hoper is not always a no-hoper. You've always just keep on trying. So if you go, please, finally, this will be my final shot, to number 14. Is it number 14? No, not number. Go to the next one. Yeah, right. Causing harm, making matters worse. Keep an eye open for Tyndall, which won't be, it'll be a while till the decision comes out, but that might throw some light on this. Might there be a duty based on positive acts which make matters worse? And I give two examples there. These are slightly new, altered versions of real cases. A terrible, tragic suicide, I don't know or not, taking of his own life, of a boy who had real drug problems. So zero tolerance drug policy, the posh private school, staff expressing internal profound concerns, not making the parents aware, nothing done, so that's an omission. Peer group knew about what was going on. They were desperately worried about him. In the subsequent inquest, there were terribly upsetting WhatsApps about what the hell can we do if we speak, he'll be expelled. Question, overly harsh policy, did that make matters worse? Interesting point. Similarly, on the sexting cases that I know exist, and I've had a couple of them, boy accuses girl, boy denies, no fair process, boy prosecuted, school assist prosecution, prosecution abandoned, boy exonerated, girl fabricated, causing harm, making matters worse, as opposed to any of the more traditional ways that it could be put. So there we go. I've left 35 minutes for my colleagues, and I apologize. I should have said there is at the moment no chat function, but it may well be opened when Lameesa ends, and I apologize for being so verbose. Nothing new there.
Thank you very much, Nick. And no, it was very, very interesting. I think we could have listened to you for the hour, but it's my turn. So unfortunately, I don't think I'm going to be as interesting as Nick, but I might be a wee bit quicker. So first slide, please. I'm going to be discussing post-16 and higher education. It's a web. That is, I think, the title of my slide there. What I'm going to be trying to do in my 15 minutes or possibly less is speed through the statutes, the bodies in play, the possible remedies that can be offered for breaches, at various stages of these types of complaints. But I'm going to be focusing the majority of my time on the Abrahart case, which I'm sure you're all familiar with. And if you're not, you should be by the end of this presentation, because of its quite interesting and novel applications to this quite complex area of law, and the commentary I'll offer on that as well. And of course, the Abrahart case was one that was done by our fantastic colleague, Sarah Steinhardt, who I believe might be on this call, pressure for me, and Jamie Burton. So that is my format. So briefly, the web of authorities that are in play. I think this is where I tend to find cases get a little bit complicated, especially in a post-16 context, because it is usually, to my mind, more complicated than the simple, small child in a school setting, possibly needs an EHC plan. Where do we go from there? Additional people are getting involved. The young person can advocate for themselves in some contexts. The education providers can often be in a different local authority if we're getting a residential placement involved. Sometimes, due to the person's age, the health body that's involved becomes more complex because they are, of course, approaching adulthood. And that's what I'm going to very speedily run through in the post-16 context. Next slide, please. So what I've done is I've picked out some of the most important statutes, provisions that are in play for a post-16 young person. Obviously, this isn't close to the number of statutes, etc., that are applicable. But I've picked out the ones that tend to crop up the most in these cases and what their applications are in this context. Obviously, with the local authority, the local offer is very, very specific, often put in the most general terms I find that can be got away with. The respective frameworks of the Apprenticeship Skills, Children and Learning Act can be applicable, though it's something I tend to see a bit less of. And local authorities are, of course, expected to liaise with the education providers, with the healthcare bodies, with the parents, with the young person, etc. Now, we all know easier said than done, but that is the expectation upon them. And of course, I think most importantly at this particular stage, the upper tribunal has held that a young person could still benefit from educational provision. It doesn't have to be towards formal qualifications, and that is most often, I think, when we see residential placements, working day curriculums, etc., brought into play. Next slide, please. In terms of the providers themselves, again, they must publish their SEN information reports. They must have somebody responsible for that care provision, usually a SENCO, somebody in charge of that process in their school. That's not new information. What I think can be tricky with the educational providers is when it comes to the cost of those reasonable steps they have to take to make provision for a disabled young person who is to meet those costs. I think, sadly, at the end of the day, these days, it always comes down to, well, who is bearing the cost of this provision? And that is not immediately obvious, and that can be something that can get quite complex depending on what your situation is. And I've just listed some of the more usual provisions that I tend to come across for support provided on that slide. Next slide, please. Health bodies. Now, this is less usual, I think, that they're involved, but when they are involved, the matter is usually one that is quite a complex situation. They, of course, have the duty to bring certain children to the local authority's attention. I think when we're talking about a post-16 context, it tends to have already been brought to their attention quite clearly by that stage. But the CFA creates a duty to ensure cooperation. And sometimes that in itself can cause quite a range of tensions and complexities, because what a health body might think to be in the best interests of the young person might not be what the local authority or the school think, or what the resources necessarily allow, although that shouldn't really be the consideration. So I think what I'm trying to get at here is the very complicated web of how all these different considerations have to be fought with a post-16 situation. And I think it very much tends to be split into a school aged or a school placement versus a higher education situation, because then you pretty much only have the university involved, and that's a very different situation. So this is probably more to do with the school-aged child. Next slide, please. And of course, residential placements, which I think not always, but most often tend to come up with the post-16 young person. And it's obvious why. The complexity of their needs has increased at that point. And some of them include elements of healthcare provision. Of course, the national trial is a massive consideration when we come to these particular cases. And usually when the national trial is involved, my experience tends to be there is more cooperation between the various bodies in play, although perhaps that is a slightly overly optimistic statement from myself. Next slide, please. So I'm just going to whiz through the various remedies that can be appropriate if provision is not being provided for, etc. I think the difficulty when there are so many statutes, bodies, opinions, thoughts about what is best for this young person, this child, it's sometimes difficult to go, well, what is the correct solution? How do we get them the provision that they are entitled to? I also appreciate I might be preaching to the choir, because for some of you, I'm sure this is your everyday. So apologies, and I'll make this part even briefer. But for those of you slightly less familiar, perhaps this might assist. When is a pre-action protocol letter or failing the efficacy of that JR appropriate? And that's when it's a flat out denial of legal responsibilities effectively. And most usually in a post-16 context, I find, though maybe others have different experiences, but that is a local authority not providing education. It's not adhering to the expected timescales. Usually when that's the case, a PAP letter sorts it out. Rarely have I seen the case where PAP letter has not had effect and we then go forward to a JR. Or we start prepping for our JR and a local authority holds up their hand and goes, whoops, and gets kicked into gear, as it were. EOTAS packages and waking day curriculums not being sorted in a timely manner also seems to be where this comes into play quite a lot. I've also had a couple of cases recently where, and actually one of them had nothing to do with or a residential placement rather. When multiple local authorities are involved, I have seen a bit of a, pass the buck, as it were, as to who it is that has responsibility of the varying provisions of that young person's EHC plan. And actually, in this particular case that I'm thinking of, it was national trial, one local authority was saying they only had responsibility for the education, but the other local authority was saying they had responsibility for the health and social care. But then it got more complicated than that. But I think this is much more likely to occur in the post-16 context, given that a residential placement could be in a different local authority, for example, and resourcing considerations mean that local authorities are more likely to fight these types of issues. Next slide, please. When's the county court appropriate? I think the majority of those cases are going to be at the university level. Usually when they're at the school level, I tend to find it's discrimination on a wider scale. Frankly, I've usually seen them in relation to race discrimination cases, not necessarily disability. And it's when the internal complaints process of that particular body has not yielded any results, but it's of more limited application, I would say. It's Equality Act breaches as well. Next slide, please. And when's the sendist appropriate? Well, largely and mostly relating to an educational health and care plan, although of course that has so many phases to it that we go to the SENDIST for varying issues when there's a needs assessment that hasn't been considered, although it's such a low threshold that frankly the local authority never really has an appropriate argument for it, but they will drag that out in my opinion. The provisions of the HC plan aren't appropriate themselves, and then most commonly that the school placement being put forward is not one that anyone thinks is suitable. Next slide, please. So that was my as quick as possible whiz through just the varying provisions in play. I'm going to turn to Aberhart and I'm going to try and be quick. This case is very, very recent, and to my knowledge, although I'm very happy to be corrected, I think is the first court decision on a claim against the university under Part 6 of the Equality Act, either in a very long time or at all. Perhaps Nick might be more of an authority on that. But what I'm going to do is I'm going to go through a summary of the decision, or a summary of the facts, then the decision at first instance, then what the High Court has found, and discuss the parameters of sort of duty of universities to disabled young students and give a bit of commentary. So next slide, please. So I'm not going to spend too much time on this. I'm sure most of you are familiar, but a young lady named Natasha, she was enrolled on an undergrad program. Her first year went somewhat smoothly. She was fine academically. Her friends knew that she was quite socially anxious, for example. She had trouble placing an order in a restaurant, that sort of level of anxiety she was suffering. However, things rapidly deteriorated in her second year. There were multiple requirements of her course that she had to give oral presentations, interviews, effectively participate in class for her grades. And these were measures of how the university measured academic performance in these students. She very sadly couldn't cope with these presentations. They heightened her anxiety to such a degree that her mental health really severely deteriorated as a result. I think it's common ground that limited efforts were made to assist her on the part of the university, and on the date she was expected to make a large oral presentation, which was a significant part of her grade, I believe. She was very, very sadly found in her room having committed suicide. Next slide, please. So the claim was brought on her behalf by her father for damages under the Equality Act and in negligence at common law. Now, I haven't really gone into the negligence claim because that is, of course, Nick's area, but suffice it to say it wasn't a successful claim in negligence, very much following what Nick was telling us about the trajectory of these cases. However, breaches of the Equality Act were found. Next slide, please. So 3 main breaches were found. So the university had breached its duty to make reasonable adjustments to this young person. Effectively, the university said, well, the oral assessments, the interviews, etc., were competency standards, and one of the exceptions to the reasonable adjustments provisions in the Equality Act are where competence standards are at play. However, the court found in this particular case that the oral assessments didn't amount to a competence standard. The oral assessments were simply a method of assessment. They understood what the assessment was there to do. They agreed that, well, needing to find out if the students had X requisite level of knowledge was a standard that could be applied, but not that that had to be found via an oral assessment, effectively. And this method of assessment had substantially disadvantaged Natasha, and it's one that should have been adjusted. And the university, I'll come to this later, but effectively, after there wasn't a formal process that Natasha was engaging in, and also that the university didn't really make efforts to progress, they had effectively stalled in their help that they would provide, and that was found to be in breach. Another breach was found was that the university had indirectly discriminated against Natasha, and the university tried to put forward an argument that a comparator was someone with similarly poor skills of oral presentation, and that was rejected. And thirdly, that the university had treated Natasha unfavourably because of something arising, so a Section 15 claim. Now, there was no dispute, I think, between any of the parties that marking her down and imposing penalties was unfavourable. However, this is, of course, a claim that could, or sorry, a provision that can be justified. But the university's justification defence did not succeed, given their knowledge of Natasha's disability. Next slide, please. So the university they were ordered to pay, it was about 50,000 of compensation, and they appealed to the High Court, and that has very, very recently come out, and that's where we are now. All findings of breaches of the Equality Act were appealed by the university, and the claimant cross-appealed the finding of no duty of care, which was, I believe, it was unsuccessful, but it was more that the High Court declined to even comment, frankly. But in terms of the Equality Act claim, and I'm aware that I'm losing time, but I don't think I can speak any faster. The primary considerations for the court were effectively regarding the oral assessment. So the university disputed the lower court's findings about what constituted a competence standard, and then consequently whether or not the university were in breach of their duty. So the High Court agreed with the findings of fact from the court below. And this is, I think I basically just outlined this. What was tested was knowledge rather than oral communication. Effectively, the method of assessment did not have to be what it was. That is what they found, and they upheld the lower court's findings on that. Next slide, please. With regards to then the university saying, well, we had made all the reasonable adjustments that we could have. And the reason they said that in the appeal was they said, well, they didn't have the knowledge, the expertise, or the evidence of what Natasha was suffering to be able to take appropriate steps to assist and to make said reasonable adjustments. They said without their disability support services being involved or specific medical evidence, the steps they did take were reasonable. And the county court had found that the university knew that Natasha was suffering from a certain point. And I'll come into this in my commentary, but effectively, the High Court said, no, this isn't a case where that is a defence that's open to the university, mostly because it was so obvious what Natasha was suffering. And there was engagement in a limited sense with disability services, etc. But the university were aware, and her tutors were aware, and her tutors had even attended her GP with her. And it was obvious what it was that she was suffering. And actually, very importantly for our purposes, the university's reliance on its own policies couldn't be it was not something that was open to them to do because they weren't the law. And by inference, they could be adjusted as part of a reasonable adjustment to alleviate the disadvantage suffered by Natasha. Next slide, please. Louise, I will be 1 more minute. So in this case, as I say, it was very clear what Natasha was suffering from, and therefore requiring things such as a support plan put in place by the disability support services, the court held was not necessary in this case. But they did go on to say very deliberately that many disabilities are hidden, complex, and require expertise, which is obviously true. So it's not that the court said that it was unreasonable in any circumstance for a university to require medical evidence or an assessment of needs, etc. So, as is the case with pretty much all of our cases, Abraham is fact specific, and that should not be applied across every single case that comes to bear. It's a university's responsibility to consider reasonable adjustments. It's not the student's responsibility. That was a very important fact in this case because one of the university's claims was that Natasha wouldn't engage with services. But that was not her responsibility to do. It's an anticipatory duty, frankly, to make reasonable adjustments, and that's common ground. And I think this case highlighted the importance of everybody being provided with training on their Equality Act duties, but I think most cases, frankly, highlight that importance, don't they? Next slide. I have this, and I believe I have one more slide. I just wanted to highlight a few very important cases that were cited in the High Court decision that I think link in quite well with our themes here today. So Cosgrove makes it clear that there's no requirement for the claimant to have identified the adjustments which they say ought to have been made. They must have been identified by the time everyone's bringing a claim. But during the university, again, that goes back to that anticipatory duty, and that's not something the provider can rely upon. It's not up to the person who is in need of the assistance to say what should be done. Reasonable steps, it was just again highlighted, Allen and Royal Bank of Scotland, what is reasonable. It was also highlighted that what the defendant, what the university thought was reasonable, is an irrelevant consideration. It's always for the court. So that is not something a university can rely upon either. And a university cannot refuse to take any steps citing that it wouldn't completely avoid the disadvantage. That's not a defence that's open to them. They have to take steps, even if it would only alleviate some of the disadvantage caused. Final slide, please. I have just highlighted this particular paragraph from the judgment. It's paragraph 267. I believe it's the penultimate page of the judgment, and it effectively sums up what the lessons to be learnt in this case are with regards to the provision that should be provided for disabled young people at university. And it's really important in light of the resourcing debates that are going on a daily basis. Something this important, something this obvious should have been picked up on, and the resourcing issues facing the university were not a defence that was open to them. Something should have been done. And I'm getting multiple signals to stop, so that is where I'll end, with my apologies to Louise.
Not at all. Thank you very much, Lameesa, and to Nick. Well, I'm going to talk about some recent cases from the upper tribunal dealing with SEN issues and the type of things that come up very frequently in the first-tier tribunal, or the first-tier tribunal has to deal with, and also local authorities when dealing with the issues first instance. So if I can turn to the first slide. So the first slide that I'm going to look at is the case of OO and BO. This case against London Borough of Bexley, and it was a case that concerned the application of section 39(4)(b) little 1 Roman numeral 1 of the Children and Families Act. Now, of course, we know that the reason why this was particularly relevant in this case was because it was a case where a parent had requested a particular school, and of course that particular type of school rather, and that has to therefore be complied with unless one of the exceptions kicks in. And the exception that was being particularly considered in this case was that it would be incompatible with the provision of the efficient education for others. In other words, the words of section 39(4)(b)(1). And the authority considers exactly what that requires. And the reason why I've included this is because I think that the comments of the upper tribunal and what they held gives a particular light as to what might be needed and what must be considered by the first-tier tribunal and by any parties when dealing with this particular statutory provision. The upper tribunal described the test as a sophisticated one, and they went on to say that what they meant by that was that it needed to be carefully and precisely considered. If we can go on to the next slide. It said that the first-tier tribunal in this case had simply held that the quality of provision for the existing pupils at this particular academy would be materially affected, and that reasoning was not considered to be sufficient. The lack of sufficiency of reasons is perhaps not surprising in that circumstances, but the upper tribunal went on to give guidance as to what they would expect to be considered, which is perhaps the most helpful part of the decision. They considered the case, or perhaps reconsidered the case rather, of Essex County Council and Sendis from 2006, where it was said that the word incompatible is a strong term and meant more than simply prejudicial to. And we can see from the next slide that the upper tribunal broke down what needed to be considered into 4 particular questions. I'm pausing there before we look at what the specific questions are. One of the most interesting things perhaps is that they considered, well, what standard does this need to be judged against? And they, as you can see in the second question there, they describe it as the efficient education standard. And one of the things that they did was that they built upon NA and the London Borough of Barnet from 2010, where the upper tribunal had effectively accepted the submissions of counsel that it was not enough for the standard to be reduced from the very highest to something a little lower, but nor was it necessary to show that no meaningful education would be provided at all to a particular child. In other words, the standards, frankly, were somewhere in the middle. So the 4 questions, therefore, are which other children's education would be affected, what was the current standard being provided, would the particular attendance that was required have an effect on that standard, and also most particularly whether or not, if there was a reduction in that standard, could that be avoided? In other words, could adjustments be made to avoid it? So I think this gives a particularly helpful guidance as to what the particular issues that need to be considered by either a local authority or by the first-tier tribunal standing in the shoes, as it were, of the local authority on appeal, but also in terms of the type of evidence that's going to need to be considered and brought before a tribunal, or indeed whether you wish to rely on the exception or rebut a reliance on the exception, the type of evidence that's going to be relevant to that. I think it is particularly helpful that the authority shows that simply saying or simply asserting that there's going to be prejudice or that there's going to be a material impact clearly isn't going to be enough. Now, looking at the next case, if we can move on to the next slide, of LC, RC and Hampshire, again a case from last year, and this concerns the difference between the word suitability in section 39 and appropriateness in section 40. The facts of this case, simply put, in very summary form, were that the appellant didn't want the school that was named in the particular individual's plan, EHEP plan, which was, in this particular case, an independent special school. Instead, they wanted section I of the plan, i.e. the name school, to be left blank and for education to be provided otherwise than at school. So the correct test, therefore, was whether the school was appropriate, in other words, the wording in section 40. And perhaps unsurprisingly, the upper tribunal found that there had been an error of law because the first-tier tribunal had applied the test that sits in section 39, in other words, the suitability question of the school for the particular age, aptitude, ability, or special educational needs of the child in question. And just to be clear, as I've put in the final bullet point there, the reason, of course, that section 40 was the relevant test was because the appellants hadn't requested a particular school. If we can turn on to the next next slide. The tribunal found, as I've said, that it was an error of law, which is perhaps unsurprising in the circumstances, given that the wrong legal test had been applied. But they went on to say that it wasn't a material error. And the reason for that in this particular case was that they found that they considered that material wasn't the error wasn't material because it wouldn't have made a difference at the end of the day, despite on the facts, despite the difference in wording. However, from the tribunal's decision, it is quite clear that different facts could produce a different outcome. And they describe the test. The correct test should have been the holistic test under appropriate, rather than the circumscribed test under the suitability criteria, circumscribed on the particular language of the statute. And I think that gives some indication that under a test where appropriateness is the word that needs to be considered, there's going to be scope for considering wider considerations or a broader test than when you're just looking at suitability. On to the next slide. I'm conscious of time. So on to the next slide, looking at the next case, AA and BB, and this is a case against Bristol. The this is where a case where LA had sought a particular placement, and during the actual hearing from the particular school that the LA were suggesting would be the appropriate school, or the school where they wanted to place this individual, the school said in the hearing that they could no longer offer a place, so they resiled from that. The other side, the appellants were arguing that they wanted a year of education otherwise than at school, and then a different school placement starting the following year. Now, in light of B School's evidence, no one sought to adjourn the case. That's significant for the outcome at the upper tribunal. If we can move on to the next slide, just reminding ourselves of what section 61 says. This is obviously the provisions regarding when education provision can be made otherwise than in a school. And you can see there at subsection 2, an authority may only do that if it's satisfied that it would be inappropriate for the provision to be made in school or post-16 institution or at such a place. Now, if we can move on to the next slide. In this particular case, the First-Tier Tribunal had found that for the purposes of section 61, the absence of a specific placement option didn't make a difference, essentially, didn't make it inappropriate to make the special educational provision in the school, in a required school. So that's perhaps, from a practitioner's point of view, interesting, because it means that section 61, the consideration of section 61 can be completely absent of whether or not there is or isn't a placement available. And in this case, the tribunal, this is the First-Tier Tribunal, went on to name not a specific school in section I, which unsurprising as there wasn't an offer of a placement, but instead they specified a type of school, i.e. a mainstream type of school. Of course, the knock-on impact of that is going to be that the local authority then, of course, have to find that placement very, very quickly, as once it's named in section I, of course, the duties to do so are engaged. And the tribunal reasoned that the absence of a specific placement, despite the efforts of both parties, was not sufficient to engage section 61. Now, if we can turn on to the next slide, that was something that was upheld by the upper tribunal, but particularly in this case, they were looking at the issue of fairness, and that's what permission to appeal was granted on, the fairness of the fact that this all happened in the hearing, that the B School resiled from the offer, and that whether or not the appellants were given sufficient time in order to respond. And if we can look on to the next slide, as I'm conscious of time, the upper tribunal found there was no unfairness in the circumstances, and the operation of section 61 was not impacted by the removal of the offer. So hopefully that clarifies that they upheld the First-Tier Tribunal's decision. What is perhaps interesting, and one of the reasons why I wanted to bring this to everyone's attention, is that they also repeated what had been said by the upper tribunal in the earlier case, 2020 case of AJ in the London Borough of Croydon. In fact, it was actually the local authority that relied on this, interestingly. But they said that the authority's duty as a hearing is to assist the tribunal by making all relevant information available, not to provide only so much information as assists its own case, and should place all its cards on the table, including, of course, those that may assist the appellant's case, or rather the parent's case, and that in appropriate circumstances, the authority's duty might extend to obtaining further evidence. And I think that's a helpful summary of what is essentially could be equated with the duty of candour, or certainly equivalent to that, in terms of the approach to be taken, certainly not that it is adversarial. And then turning on now to the next slide, and the last case that I'm going to look at. This is the London Borough of Croydon and KA, and it concerns the proper interpretation and application of section 9 and the specific factors that need to be taken into account in balancing what is unreasonable expenditure for the purpose of section 9. If we can move on to the next slide, we can see what section 9 says. And essentially, the balancing exercise there stems from the fact that the tribunal has to consider, when dealing with requests, or giving due regard rather to requests from parents to be educated, their children to be educated in a particular manner, they have to consider the avoidance of unreasonable public expenditure. And if we can go to the next slide, that of course concerns what we called a balancing exercise. And the balancing exercise is to consider the advantages of the parental preference versus the expenditure. And the question was, what should be considered when considering the advantages? How wide the advantages that can be considered? And there was arguably conflicting upper tribunal authority on this, at the case of Kay and Hillingdon, which said that, and I've set the quote out there, said quite clearly at paragraph 29 that the tribunal, and indeed the local authority prior to that, can consider wider social and health benefits, in fact, should consider them when deciding whether the additional public expenditure is unreasonable. A latter authority of KE had suggested that that might not be correct. And in this case, the upper tribunal confirmed quite clearly that K should be preferred. In other words, if we can look at the next slide, that the position very much is that K is the preferred position, and that in the circumstances that wider benefits can be considered. And the reason I wanted to look at this slide is that it gives a helpful insight into upper tribunal procedure on a particular point. Although a number of reasons were given for why K was preferred, one of them was that K was a reported decision. And as was set out in KA, a decision is only reported in the AAC if the decision and its reasoning commands the broad assent of the majority of the Chamber's judges. That, it was said, is a difference that involves an important distinction in the doctrine of precedent operated in this chamber. As K was a reported case, and I've set out there the reporting citation, it meant that it carried more weight. So that is a helpful insight, I hope, into the upper tribunal's procedure when there is conflicting authority and indeed its own reporting procedure. And then if we can turn on to the last slide, as I say, the outcome there was that the Section 9 analysis is not limited to consideration of educational advantages when you're considering what's unreasonable, but you can take into account the wider social health benefits to the particular individual. Thank you very much. That's a very quick whistle-stop tour. I'm conscious that we have run over ever so slightly our hour. I don't know if there's anybody who wants to ask any particular questions at this stage, but I think that probably, given that we've gone over time, that if there are any questions that aren't burning immediate questions, then you can email any of us or indeed all of us, and we will get back to you with whatever we consider our answers can be or will be as soon as possible. Nick, Lameesa, I don't know if you want to add anything.
No, that seems like a sensible plan to me. I think you all, our emails are all on the websites, or they're quite obvious.
I couldn't find my mute button. You're just being cowards. They are afraid that if you pose any questions now, they won't know the answer. So in my view, you should stay on for as long as possible to expose our ignorance. How about that? It's absolutely bizarre. There's no audience.
I was going to say, we're not going to be about to be cut off.
Hang on, there are 38 people. I don't know. Can we not go on forever? I'm loving this. Hang on.
I think the only question we've actually been asked is Rachel saying, will we be able to have a copy of the slides, please?
I was going to say,
right.
yes.
Okay.
I definitely
I'll do as I'm told. Whatever. If that's the end, that's the end. If anybody wants to ask any questions, I don't see why isn't it configured so we can talk to people. Anyway, there we go.
Well, good question, Nick.
We can complain to the management later.
People can use the question answer function to ask any question.
But it's good to see a real person. This is taking COVID to a ridiculous extent. I'm going to complain to the management.
To everybody asking about slides, yes, we will send the slides.
Yes, definitely.
If there are any questions.
Oh, you're not going to charge £100 a slide. Okay.
Well, you're lucky Nick isn't in charge, everyone.
Yeah, true.
Right.
Anyway,
thank you all very much for joining us.
Thank you for your patience, 38 people. Right. God bless.
Okay.
Thank you.
All right, we love you all. Right, okay.